Thank you very much for inviting us today. Thank you, ELF, CCBE, to give us the opportunity to present the Commission's work on the important topic of digitalization of justice. I send my best regards from Anna Gallego, who unfortunately, as you said, couldn't be here today. So I'm giving the speech on her behalf. We are living in a digital age where digital technology plays, of course, an important part in all aspects of our lives. This is why a true digital transformation of the justice area is one of the Commission's priorities. Relying on digital tools is essential for the resilience of our justice systems. Digital technology is also key for allowing individuals and businesses to enjoy uninterrupted access to justice. Effective justice systems require effective tools that can expedite judicial proceedings, facilitate access to justice, reduce costs, and increase transparency and efficiency in case handling. And the Commission is working hard to help develop such tools. And I think this project is a very good example where we can help to co-finance the development of tools that are relevant for your work. So let me briefly present some of the recent activities in these areas and achievements. I'm sure that many of you have heard about the e-Codex and the regulation that we hope will soon be adopted. This system is our gold standard for decentralized, secure, and interoperable cross-border communication in the justice area. It allows the national IT justice systems to talk to each other across borders. e-Codex is the technical solution that serves to underpin the digitalization of judicial cooperation. And to go one step further, the Commission on the 1st of December last year adopted the Digital Justice Package. And what is this? It comprises 3 ambitious initiatives and is a significant step forward in digitalizing judicial cooperation procedures. So broadly speaking, the Commission proposals aim to transform the traditional paper-based channels of communication into a digital one. The first initiative is the proposal on digitalization of cross-border judicial cooperation and access to justice. It aims at facilitating access to justice for individuals and businesses and at improving cross-border judicial cooperation. Here we propose to establish digital communication channels with all competent judicial authorities that they can use for their interactions. The proposal also offers specific benefits for individuals, businesses, and lawyers. For example, individuals and companies, as well as their legal and authorized representatives, will be able to initiate civil law claims and communicate electronically with courts and authorities. This includes electronic payment of court fees, which is not possible today, and it creates a practical barrier to having efficient cross-border access to justice, which I assume that you are facing quite often. Another example is that parties in proceedings will be able to participate in oral hearings through video conferencing. And that includes also suspects, accused, and convicted persons, as well as their lawyers. And this proposal, of course, includes safeguards on the fundamental and the procedural rights of individuals. We have, for instance, paid particular consideration to guarantee the confidentiality between the lawyers and their clients in the online world. In fact, the use of digital channels can reinforce the protection of fundamental rights by ensuring uninterrupted access to justice and seamless participation in hearings, regardless of distance or any force majeure circumstances. And we believe also that this proposal will bring benefit for you, the lawyers, in your daily work, because digital tools facilitate work methods and reduce time and costs. And the second part of this digital justice initiative is the proposal on the digital information exchange in terrorism cases. This proposal aims at improving the functioning of the European Judicial Counterterrorism Register at Eurojust. It focuses on digitalizing also overall information exchange between national authorities and Eurojust. And then finally, the third proposal is to set up an online collaboration platform for joint investigation teams, the so-called JITs. As you probably know, JITs can be really successful, and it's increasingly used because they allow an efficient investigation in major cross-border cases. But at the same time, these teams need appropriate and secure collaboration tools. So that's why this new IT collaboration platform will increase the efficiency and effectiveness of cross-border investigations and prosecutions. So this digital justice package that I've just given you a brief overview of lays down a comprehensive and ambitious three-pronged approach to modernize cross-border justice. It's in this broader context of digitalization of justice that today we are discussing the role of a specific set of technologies in the justice area, artificial intelligence. Artificial intelligence provides many opportunities for lawyers, for practitioners, for the judicial authorities. It's essential for creating robust search facilities that allow better access to case law for legal professionals and the general public. Seamless access to and easy reuse of case law allow for innovative legal tech applications to support the work of practitioners. And the practitioners who use these applications can become more efficient and can reach clients who could otherwise probably not permit themselves or afford to seek legal advice. Legal practitioners can also perhaps better play their gatekeeping role when advising clients on the likelihood of success when bringing cases to courts, if they can use algorithm-based solutions. But as we have heard here, at the same time, there are risks. There are risks of bias. There are technical limitations if people don't know how they use these tools. So practitioners also need adequate expertise to critically evaluate the output of algorithmic tools they may use. For example, just to give you an example, a software that processes historical data could suggest that a father has little chance to win a child custody case. That's something that perhaps an algorithm has used historical data to be developed, and the output is based on societal conventions or even bias that might not be relevant anymore or might be able to be addressed by an excellent lawyer. So that can have an output of such AI tool can have an impact on the legal advice or outcome of the case if the lawyers or the authorities don't have the necessary understanding of these tools. So as Mr. Vitanov also explained very well, there are enormous ethical challenges and risks that we need to be addressing at the EU level. And this is why in April, as we heard last year, the Commission presented the proposal for a regulation on a European approach for artificial intelligence. The objective of this proposal is really the core objective of this AI Act is to ensure the protection of fundamental rights and safety when AI is used. Therefore, it includes specific provisions to enhance the effective enforcement of EU rules, and it follows a risk-based approach. We have already heard very detailed comments about that, but to sum up, we have identified high risks in areas such as education, employment, access to credit or public assistance benefit, law enforcement, migration and asylum, and remote biometric systems like facial recognition applications. It should not come, as we all know, as a surprise that the use of AI in the justice area also constitute a high risk. So let me give you an example why having such a distinction is important. We, as you very well know, EU has in its acquis many rules on how to protect and safeguard fundamental rights in digital applications and in many other areas based on the Charter on Fundamental Rights. But there are certain complex and opaque AI applications that can be challenging to understand in terms of how they work or the results they need to produce. The proposal will therefore help to make sure that high-risk AI systems are designed in a fundamental rights compliant way. The new requirements will allow possible breaches of fundamental rights obligations to be investigated and addressed by national authorities and courts. To achieve this, the proposal includes requirements to ensure appropriate documentation and testing of high-risk AI applications. This will also ensure adequate human oversight and the reliability and accuracy of the systems. But it's the users of AI systems that are the ones who need to respect fundamental rights. That's how the AI Act is drafted, and that's really important to remember. This is why the users, need adequate information from the providers of AI application, those who develop the applications and the tools, to ensure suitable use for their applications. And these aspects are therefore also regulated in the Commission's proposal. The need to respect fundamental rights holds especially true where the user is a judge or a prosecutor. As you know, your professions as lawyers and the judges and the prosecutors already have many standards on accountability and transparency and obligations under existing legislation, but they also need to fulfill these obligations when they use the AI tools. Therefore, we must make sure that judges have an appropriate understanding of the tools they use, and we are addressing that through our funding programs also on judicial training and other support we can provide. And in certain cases, the opacity, autonomy, and complexity of many AI systems can make it extremely difficult for victims who have suffered harm because of the use of an AI application for them to claim compensation for the harm they have suffered. So this is why the Commission is also now, as you probably also know, we're looking into the topic of civil liability for harm caused by AI. This is really important in order to strengthen this trust and make this the way of working that can be based on a technological solution, but it also needs to promote the take-up of this trustworthy AI-enabled products and services, which is the future. We cannot hide away from that. But if there's harm, we need to be able to address that and restitute that harm to those victims. So we need to look at some targeted adaptations to existing liability rules for this purpose. And this is why we have just concluded a public consultation on this topic. And based on the input of this consultation and other sources, the Commission will take a decision on the necessary measures in the coming months, taking into account all the feedback that we have received. So I will conclude now to say that digital transformation, the deployment and the use of innovative technologies have become key elements of the Union's agenda in the last few years. And lawyers are our strategic partners. And together with the judicial authorities, you are at the front line in our common endeavor to facilitate access to justice. So I hope that you have the support, you have understood the support of the Commission. We value this very good partnership with the bar associations and the law societies. So we really rely on your expertise and the continued partnership with you when developing these policies for the future. So thank you very much.